G'day everyone, and welcome to the final week of LA 3006 Administrative Law. This week we're going to look at the most important office that you never knew existed, the Ombudsman, the defender of the little peeps. Before we start though, a word about terminology. The word Ombudsman sounds like a gender-specific term, and in fact for a couple of years governments experimented with terms like ombud as gender-neutral equivalents. However, the word ombudsman is not an English word, it's a Swedish word, and for whatever reason the term ombud has never caught on. At state and federal level, the official term used is ombudsman. In these materials, I'm going to use the term ombudsman because that's the term used in those official materials. However, let me make it really clear from the outset that there is quite obviously no reason whatsoever that a woman couldn't make an excellent ombudsman. And if in your assessment materials you want to use the term ombud, or for that matter, ombudswoman, or any other appropriate term centered around the word ombud, you're more than welcome to do so. In this video, the first of three for this week, we're going to look at the concept of an ombudsman. Where did the idea come from? What ombudsmen are there in our system? Why do they matter? What's the difference between power and influence, and why does that matter? In the second video, we're going to look at the powers of the Ombudsman and the limitation on those powers. In the final video this week, we're going to look at the processes that you or clients might use to bring a matter to the attention of the Ombudsman. So let's begin. As I mentioned just a few moments ago, the word ombudsman comes to us along with ABBA, IKEA and the Swedish chef from the great northern land of Sweden. Having said that, history tells us that a range of cultures in the ancient past, including early Chinese, Roman, Muslim and Scandinavian cultures, had similar offices. In Sweden, in a piece of legislation in 1809, the office of the Justly Ombudsman was created. The role of the Justly Ombudsman was to be an independent observer and scrutineer of the executive government. In Australia, the role of the Ombudsman was created in 1976 as part of the same package of reforms that produced the Administrative Appeals Tribunal and the ADJR Act. Queensland had a similar office from 1974, but the office was only designated as the Ombudsman from 2001. So what exactly do they do, and why does the Ombudsman matter? Conceptually, the Ombudsman starts with the quite obvious notion that in most cases, an argument between a citizen and a government department is not a fair fight. Usually, the government agency has more staff, more resources, more expertise, more access to records, more powers under legislation, more access to the ear of those with political power. When an individual takes on the government, it really can be a lopsided kind of fight. And ultimately, it's not good for society, and it's not good for good governance if government decision makers can get away with bad decision making just because of how hard it is to take them on. Frankly, even with a lawyer on side, it's going to be tough. Only the biggest law firms have the resources to match it with the government, and the biggest law firms tend to be the most expensive. So the Ombudsman is a publicly funded service that people can go to ask for an investigation into some sort of administrative decision or some sort of administrative situation. So if that's the case, why doesn't everyone just go to the Ombudsman? Why do we have judicial review? Why do we have an administrative appeals tribunal or an administrative review tribunal? What role do lawyers have? Why do we bother if everyone can just go to the Ombudsman? Well, there are a couple of reasons. The first one anticipates the second video a little bit, but it's a crucial background concept. The Ombudsman relies on influence and not on power. The Ombudsman actually has no power to impose any remedies at all. They can't set decisions aside, they can't amend decisions, they can't force decision makers to reconsider, they can't even declare the rights of parties. If a person wants a remedy, then they're going to have to go to the tribunal or to judicial review. So if the Ombudsman has no power, then what use are they? Well, even without power, the Ombudsman has influence. There's a distinction that you might never have thought about between power and influence. I want you to imagine two groups who have a task. The first group decides that they're going to put all their names in a hat and draw one out at random, and that person will be their leader. The leader has to come up with the plan, and everyone else is just going to do what the leader says. That leader has power. Ultimately, they don't need to care about the opinions of their subordinates. They can just make rules, issue commands. Others must obey. That's what power looks like. Power is the ability to compel others to obey. The courts and the administrative tribunals, they have power. If they remit a decision and instruct the department to make it again, the department must obey. Now imagine another group facing the same sort of task. This group decides not to appoint a leader, but to try and make their decisions by consensus. However, during their discussions, it pretty quickly becomes clear that one of the people in the group has a real aptitude for the task. People begin just naturally deferring to that person. If that person is regarded as having integrity, the deference will be all the greater. When that person makes suggestions, the rest of the team are not forced to obey, but it's pretty likely they will obey anyway. That's what influence looks like. Influence can be just as powerful and sometimes more powerful than actual power. The Ombudsman has no power but considerable influence. Why? Why does the Ombudsman have such influence? Well, there are two reasons. The first is that the Ombudsman is independent, really truly independent. They do sit within a government department, but by statute, they are independent. So they don't come to their investigations with a dog in the fight or a point to prove. This is very different from an applicant who's received an adverse administrative decision. If you get a client who's received a decision they don't like, they're not independent. They know exactly how they want things to turn out. And so it's very easy for the relationship with the department to become adversarial. You're trying to prove that they're wrong. They're trying to prove that they're right. That dynamic doesn't exist with the Ombudsman. The departments know that if the Ombudsman makes a report that says they got it wrong, well, that means they got it wrong. Can you see how influential that makes the Ombudsman? Second, the Ombudsman is entitled to report their findings to the Parliament. The outcome of an Ombudsman's report is not just kept between the applicant and the department. Personal details might be removed, but if the department has made a mess of things and the Ombudsman comes poking around, the department knows that the Ombudsman's report will be placed before the Parliament. That means the report will also be made available to the whole wide world on the department's website. Let me tell you, no public servant wants to be getting a call from their minister to explain why the Ombudsman has just tabled a report saying that they mucked everything up. In turn, this means that often once an Ombudsman has agreed to look into a matter, the department is going to look very, very closely at what happened when the decision was made. Surprisingly often, the department will circumvent the Ombudsman's report by recognising the error and reconsidering the decision. Again, you can see that even though the Ombudsman has no power, their influence can be massive and massively important. So what are the powers of the Ombudsman and what restrictions exist on those powers? We're going to look at those questions in the second video for this week.